So I'm going to talk a little bit about our report, and then we'll turn it over to our more distinguished panel members. But what we're always hearing in the media, in fact, we've heard it again just in the past week or so, is that we need the death penalty for those cases that are the worst of the worst. People like Dylan Roof, people like Tsarnaev. And if the death penalty is actually used this way, that leads us to the question of why do we see cases like Leon Brown and Henry McCollum, where they were sentenced to death and spent 30 years in prison based on no evidence, no physical evidence, no evidence at all except their own coerced, unreliable, inconsistent confessions. You know, we would think that if that was how the death penalty was used, that only people with incontrovertible evidence would be on death row. But instead, we've seen 150 people exonerated from death rows across the country and 9 people exonerated in North Carolina. And so we set out with this report to answer the question of why are innocent people being targeted with the death penalty and what's happening? And to do this, we decided to look at a group of cases that really hadn't been examined before. And those were cases where people had been prosecuted capitally, but who were cleared of any wrongdoing before they were convicted. So in these cases, the state sought the death penalty against people that they did not even have enough evidence to prove them guilty of a crime, even a lesser crime related to the one that they were charged with. And in order to do this, we had to do a lot of research because the state doesn't track cases like this. In fact, they're often pretty ignored and forgotten, even in newspapers. So we searched through court records, contacted defense attorneys around the state, looked through old newspapers, and interviewed defendants like Leslie Lincoln. And so what we found are the things up on the screen. We were able to document 56 cases that met our criteria for what we consider to be wrongful capital prosecutions. So that means about 2 people a year in North Carolina. And these cases cost about $2.4 million, and that cost is defense costs only, and it is only the cost of pursuing them capitally. So even if these people had all been charged with murder, but had been prosecuted non-capitally, all of this money would have been saved. And the defendants spent an average of 2 years in jail each. So that showed us that these were not mistakes that were being corrected quickly by the system. They were things that drug on for many defendants for years. We had one who spent 7 years in jail awaiting his trial. And the total for all of our defendants was 112 years in jail. And we also found that the consequences for the defendants were huge. People came out with no homes to go to, no jobs. They had owned businesses that were lost and all of their things auctioned off. Many lost contact with relatives and people who maybe didn't support their innocence during their ordeal, and those family relationships never recovered. Some lost custody of their children. Some, like Leslie, fell into homelessness afterward. And they received no compensation and, as the video showed, often no explanation or apology after being acquitted or having their charges dismissed. And then the more disturbing thing, maybe than that, was that we found really serious examples of misconduct in these cases. That example of the DNA evidence being switched was just one of many. We saw cases of witness coercion, of the state relying on testimony of of witnesses who were completely unreliable. They were being paid for their testimony in some cases, or they were receiving reduced sentences for charges that they were facing in exchange for their testimony. And lastly, the big thing we found was that in many of these cases, no one was ever arrested and tried and brought to justice for the crime. So the people who actually committed the crimes were left on the streets. So what all this leads us to is the conclusion that the death penalty, instead of being used just for the worst of the worst, is actually being used as leverage for the state in really weak cases. And it's actually being relied on often more in weak cases, because instead of proving their case in front of a jury, they want to be able to get the person to plead guilty, confess, and spare them from having to prove this case that they don't have much evidence in. So it's become, the use of the death penalty has become a substitute for a thorough investigation in some cases. And a large majority of murders are being charged capitally so that the DAs can use this leverage whenever they choose. So that's what we really found, is defendants are being left with nothing. They're often not even newspaper stories saying that they've been cleared in these cases when they're over. But that they're not really the only ones paying the price for this. That our state is wasting millions of dollars on using the death penalty in cases without strong evidence, and that killers are not being arrested and brought to justice.
Thank you, Kristen. So it's a pleasure to be here. I'm going to just get up and speak out here. Pace, nervously.
It's fine.
I see all of my friends here, so I'm really happy to be in this group and speaking to this group. I want to say before I start my planned remarks how important Policy Watch has been in this whole process on the issue of the death penalty, on other very important progressive issues, specifically with regard to my client, Henry McCollum. Policy Watch was there after Henry McCollum and Leon Brown were exonerated both by the district attorney and by the judge. And they were there counting the days, counting every day that the governor waited to grant a pardon of innocence. And I think it had an impact, but more importantly, it reminds us of the actual costs to individuals who are caught up in this system, who are innocent, and have to go through the process of getting out of prison with nothing, and then only, in this case, 9 months later, receiving the recognition from the government that they were actually innocent, and then becoming eligible for compensation as a result. So thank you very much, Rob and Chris, and all the other persons in Policy Watch that worked on that issue. So I represented Henry McCollum for almost 20 years. And I'd love to be able to say, because of my great work, because of my intelligence, that this thing worked out so well. But keep in mind, Henry McCollum was on death row for 30 years. And really, the 20 years that I worked on his case were filled with a sense of frustration and a sense of futility. And what I want to talk to you about just for a few minutes today is what happened. Why is it that innocent people 30 years ago were sentenced to death, and it took 30 years for the state to recognize their innocence? And what does it mean in terms of our public policy and the death penalty? And what does it mean in terms of our study that 56 people were innocent, and yet the state was seeking the toughest punishment, the maximum punishment, the death penalty in their cases, which means they were not eligible for bond, and as Kristen so well said, their lives suffered tremendously as a result. So there were 3 pieces of evidence at Henry McCollum's and Leon Brown's joint trial in the early 1980s, 1983. 3 pieces of evidence that were used to convict them. The first piece of evidence was confessions of each of the men. And those confessions, as you might have read or heard, were taken under tremendous pressure. These are 2 persons who are intellectually disabled, Leon's IQ was in the 50s and Henry's IQ was in the high 60s. The confessions were taken with pretty sophisticated techniques, and this is what I mean by that. The prosecutors came in and said, we know from an informant that you guys did this. So we already know you did it. But you can help yourself. You can save yourself. This is what you have to do to save yourself. And Henry, by the way, was told, you can leave. Just tell us what happened and you can leave. But this is what we know. We know that you did it. So if you can tell us, if you can give us, some explanation, maybe you weren't the principal persons. Maybe you weren't the person who actually killed the young girl. Just tell us who else was involved. And so Henry McCollum made up a story. He made up a story with people he knew. And by the way, these guys were from New Jersey in a small town of Red Springs, North Carolina. They're in the small town, they're African American, intellectually disabled, and what the police did was round up the usual suspects. They rounded up people that no one knew. And Henry McCollum fit that description. They rounded up out-of-staters, African-American out-of-staters, and that's who they thought, because they knew everyone else, and no one else would have done this crime. Or they thought they knew everyone else. And as it turned out, there was one other guy they did not know who was the actual perpetrator. So Henry McCollum makes up some names, and this is the key. The police supply the details from the crime search, from the crime scene, and from the autopsy, and they put it in the confession. No one else could have known that. So think about it, if you're the jury, if you're the community, if you're judging guilt or innocence of Henry McCollum and Leon Brown, the police present confessions that have details that no one else could know except the police and the perpetrator. And then the police testify that these details came from Henry McCollum. So that was the first thing. The second thing is, 3 days after this confession, Henry McCollum is being brought up for an arraignment. And there's a news camera guy that catches him in the hallway and says, Henry, did you do this? And he says, no. But then he says, well, who did? And then he gives a couple of the names of people he had named in the confession. And then he says, well, what did you do? And Henry says exactly what he had told the police in the confession and what the police had asked him to say, and that is, I just held her arm down. So the technique that the police were using, not so sophisticated, is what's called a maximization-minimization technique. That is, they say, we already know you did it, you're gonna face a death penalty, you're gonna fry, just tell us what you did and tell us who really did the crime. So Henry, who's intellectually disabled, said, well, I just held her arm down. And these are the guys. So the confession's the first thing. The second thing is the videotape. 3 days later, after the confession, when Henry is not being coerced, doesn't have a gun held to his head. And he says, I just held her arm down. And what we know from all our research and all our history is that persons with intellectual disability tend to confabulate. They tend to tell authority figures what they want to hear. Henry McCollum thought by saying that he was helping himself. He did not know. He did not understand that was going to put him on death row for 30 years. The third piece of evidence. A friend of Henry's and Leon's, an acquaintance of Henry's and Leon's, L.P. Sinclair, told police or testified that Henry told him that Henry had done this crime. So he's in other words, he's corroborating the confession that Henry and Leon had done the crime. Well, it turns out L.P. Sinclair is an habitual liar. His attorney testifies at a retrial that L.P. Sinclair has a reputation for lying, but there's more. There were statements by L.P. Sinclair that to the police that were never disclosed until last year, 30 years later, they were disclosed to us. L.P. Sinclair had made 2 previous statements to police and told police that he didn't know anything about the killing of Sabrina Bowie. He had no information about that killing. And he was polygraphed, and he passed the polygraph. Henry McCollum's attorneys never knew that. His trial attorneys never knew that. I did not know it until my 19th year of representing Henry McCollum. So that's it. The confessions, the statement on videotape to the reporter, and L.P. Sinclair's statements. When I first got on this case, and I'm telling you this in part because I want you to understand that this system is not foolproof. I mean, I think most of you know that, but this is how an innocent guy stays on death row for 30 years. And I want to add one point about this that I think is really important. He had bad attorneys when he started off. So when they had the first trial, he had attorneys that were very busy and didn't have the time to do an investigation and assumed all the prosecutor's stuff was right and put Henry McCollum and Leon Brown on the stand to testify, and they were not prepared. And yet, when they testified, they said the confession was untrue, and none of this was true, and the jury didn't believe them. His second set of attorneys were a list of who's who in North Carolina in the legal profession. Some really sterling, amazing people who have made a tremendous record for themselves. Adam Stein represented Leon Brown at his retrial. Adam was the first appellate defender in the state. Tom Maher represented Leon Brown at his retrial. Tom is now the head of Indigent Defense Services for the state. Marshall Diane represented Henry McCollum on his retrial. And Marshall is a lifetime capital defender and a wonderful attorney. And Jim Fuller represented Henry McCollum. Jim was a great plaintiff's lawyer, a great trial lawyer, is a great trial lawyer, and ran, some of you may know that he ran for the state Supreme Court and came very close to winning an election for the state Supreme Court justice. Great attorneys. They looked at this confession. They looked at the fact that the details in the confession could not have been known by anybody but the police and the perpetrators. The police said, sworn testimony, that these details came from Henry McCollum. So in order for them to challenge the guilt of Henry McCollum and Leon Brown, they had to say the police lied. And Henry McCollum was telling the truth. And knowing that Henry McCollum and Leon Brown had already lost their first trial, and risking the fact that if they said that and lost, that there would be, in their minds, a greater chance that they would be sentenced to death. So both of these sets of attorneys represented Henry and Leon at a retrial, acknowledged that the confessions, these false confessions, were true. And both men were convicted. Henry was convicted and sentenced to death on the retrial. Leon was convicted only of rape and sentenced to life imprisonment. And the reason he was convicted only of rape was his confession said, well, I participate in the rape, but then when it came to the killing, I said, don't do it. And his confession, again, was a product of these techniques about maximization, minimalization. You go for the most severe punishment, and then you tell the defendant, help yourself. The only way you're going to help yourself is to say you did something less. Leon, fortunate for him, said, or somewhat fortunate for him, said, well, I didn't kill her and I didn't participate in the killing. I just participated in the rape. Again, totally untrue. So for 19 years, what did we do? We challenged the confession. We said we got experts, neuropsychologists, we got psychologists, we did lots of testing. We showed how these men were intellectually disabled. We showed how the confessions were internally inconsistent with the facts of the scene. We showed the confessions conflicted with each other. Our experts said that these men did not have the requisite intelligence to use the language that was contained in these confessions, and no one cared. No one cared for 19 years. So what happened? We finally did testing when a DNA statute was passed in this state, one of our good reforms. And our testing revealed that Henry McCollum's and Leon Brown's DNA was not on a cigarette butt that was found at the scene of the crime and that was smoked by one of the perpetrators of this murder. So that seems to be exculpatory, and we found that out 7 years ago. But the problem was, Henry's confession said he didn't smoke that cigarette. He said one of the people that he invented at the scene had smoked that cigarette. And so it was not exculpatory by itself. Here comes the Innocence Inquiry Commission and decides this is a good case with very little evidence, no forensic evidence to investigate and to work on. And what the Innocence Inquiry Commission did was run a DNA test on the cigarette butt, again, and then compared it to the CODIS database. And that made all the difference. So the CODIS database, on the CODIS database, was another defendant by the name of Roscoe Artis. And Roscoe Artis had committed almost exact same crimes several times. Once in Red Springs, North Carolina, 3 weeks after the killing of Sabrina Bowie. Had been on death row in North Carolina, and then had his death sentence reduced to life imprisonment. So once that CODIS had happened, we were sure two things. Roscoe Artis had committed this crime, and Henry McCollum and Leon Brown were innocent. The rest you know. The DA was sure of it, the judge was sure of it, and finally, the governor of North Carolina was sure of it. And they got their pardons of innocence. Now, is this a success story? Is this something we can be proud of? Is this something I can be proud of? Absolutely not. And the scary thing is, if that cigarette butt hadn't been there, hadn't been found, there's a good likelihood Henry McCollum would have been executed, Leon Brown would have stayed in prison. There's no doubt they would have stayed in prison. And the question that we're raising with our study is, if this happens to a guy on death row with good counsel, and these 56 people who we've identified are innocent, and in part because there's weak evidence, the prosecutors are seeking death in order to have bargaining power. How many more Henry McCollums and Leon Browns are we going to find, and how many innocent people are going to be executed in this state? So, thank you. Yep.
so your microphone is sort of weak, so we've actually turned it off. So you're gonna just be on your own.
All right.
You're gonna just have to project.
Can I be over here? Is that going to mess you up?
Not at all. You want the slide up here?
No, I just want to set my notes.
No, you're fine.
All right. So the disadvantage of following Kristen Collins and Ken Rose is that most of the salient points have been made, right? And I'm not sure how much I can add, but I've got 3 points that I'm going to try to make to you, and then we'll open it up for questions and comments. So the first thing I want to say is that the thing that's striking about the report to me is that it shows that the risk of sentencing innocent people to death and executing them is a clear and present danger. The temptation, I think, when we think about the exonerations, what's startling to us is how long it takes, right? 30 years for Leon Brown and Henry McCollum, nearly 40 years for Joseph Sledge, who was lucky enough to have been charged with a murder in 1976 when we did not have a death penalty. Could have easily been executed rather than in prison for 38 years before he was exonerated. And I think it's tempting in those cases to think, well, so that's how we did it in the 70s. And that maybe is how we did it in the 80s or the early 90s. But surely things are better. And we have made reforms. And of course, as Rob pointed out on the outset of this, 2/3 of the people on death row were sentenced in the pre-reform era. But what the study showed was that we have 2 cases every year, right? This is a persistent, consistent problem. We are not solving it. The tinkering we've done has not fixed the problem. And this comforting idea we have that things are improving has proved illusory. The case that Kristen mentioned, the fellow who'd been on for 7 years, Gregory Chapman from Duplin, he was arrested in 2007 and finally found not guilty by a jury after 30 minutes of deliberations on March 31st of this year. Okay, this is a current problem. And he also had good counsel. So the inability to solve the problem is really something that weighs heavily, should weigh heavily on all of us. The second thing I want to say is that the fact that the folks in our study were ultimately acquitted or that the district attorney dismissed the charges does not prove that the system works, right? That would be an argument we could anticipate. Well, you know, the jury made the right decision. They heard the evidence, they weighed it, they realized they weren't guilty, so what are you complaining about, right? But again, because of this the persistence of this problem, we know that it doesn't prove it. And how can we say that the system works when we wrongfully prosecuted more people in the last 25 years than we've executed, right? 56, and in that same time period, we executed about 40 people. And that's what we're doing to deter crime and make society safe. And meantime, there's more people who are innocent that we've wrongfully charged. How can we say the system works when innocent people are spending years in jail and losing everything? Kristen went through a lot of that with you. And most troublingly, we can't emphasize enough, how can we say the system works when the people who killed Leslie Lincoln's mother, Jerry Anderson's wife, Michael Mead's fiance, is still out there? We've never brought those people to justice. Those people might be committing future crimes. As if Roscoe Artis had been picked up and arrested, then 3 weeks later he would not have been killing the young lady that he did in Red Springs. And then the last thing that I come to is that the system is just broken and we can't fix it. And part of that is when you look at the reasons why people were wrongfully prosecuted. It's the same reasons we see in exonerations. And it's the same patterns we see in our cases of reliance on snitches who are either getting paid for their testimony or they're getting some benefit, they're getting Crime Stoppers money, unreliable FBI evidence. You know, we know in our state that the Attorney General commissioned a report and is reported in the News and Observer found that, that for years there was a pattern of reporting misleading and inaccurate results, forensic testing in criminal cases, including cases of 3 people who've been executed in North Carolina. And evidence wrongfully withheld. These problems show up over and over. Alan Gell, you remember that one? That was an earlier exoneration. That was where the prosecution withheld evidence. Many statements from 9 witnesses, I think, who had seen the victim alive at a time that Alan Gell had an ironclad alibi, could not have done it, not turned over to the defense. And this is not what the public expects, right? We know that when polled, a recent Death Penalty Information Center poll asked people, when do you think that the death penalty should only be used in cases where there's strong evidence of guilt, and ironclad evidence of guilt? Well, that's a pretty straightforward proposition, right? And indeed, 75% of Americans say yes, that is what should be happening. We should have high standards. Who knows what's happening with that other quarter?
Yeah.
But obviously, people think that goes with the idea of it's for the worst of the worst. We actually think there should be proof of it, and we are falling far short of doing that. So we can continue to tinker with the machinery of death, but I think we know we have to recognize that there's an inevitable risk that we're going to put an innocent person on death row, that we've already done that, and that we may execute someone. There are just too many problems with this costly government program administered by fallible human beings, and all those same problems of prosecutorial misconduct, junk science, unreliable snitches. Don't forget inadequate counsel. Don't forget racial bias, right? Both in jury selection and who we decide how we're going to charge a case capitally, what race is the victim, race is the defendant, and then the decisions that juries make. And we all know the role of implicit bias on decision making in these, the most subjective and ultimate moral decision you could put to a human being. So we could set up some kind of new, little bureaucratic organization that would get all the information from the DAs and kind of evaluate it and be a check on, well, you might want to pursue this case capitally, but maybe you shouldn't because there's this problem. We could narrow our death penalty statute, right? Which would be a good idea, but we could make it only certain kinds of crimes. We could demand certain kinds of evidence. We could put a higher standard of proof, more than beyond a reasonable doubt, to the jury. But the question, I think Ken raised it for you so clearly in the McCollum case, is are we ever going to be able to really be sure that the risk of executing an innocent person has been eliminated? And we know that the answer is no. And if we can't do that, we shouldn't have this punishment.
Thank you.
Yep.
I know there are lots of questions. I have some myself, actually, but why don't we open it up if folks have one. David, you want to start us off?
Ken, I have read all of your stuff, and I would appreciate your telling us what kind of interaction do you have with the law enforcement and the judiciary when you have caught them lying, cheating, and the rest? What do they say to you? I mean, how the hell do they get up in the morning? Rarely
do law enforcement and prosecutors acknowledge mistakes. And it's really one of our serious difficulties. And but in this case, the sitting DA in Robeson County, at the end of the process, when the Innocence Commission presented the DNA hit, CODIS hit, and explained their whole process of eliminating Henry and Leon as suspects, Johnson Britt said, you have to be right. And he took the lead in acknowledging the mistakes of the state. Now, he wasn't the one who prosecuted Henry McCollum. That was Joe Freeman Britt. And Joe Freeman Britt was a really scary dude. And the law enforcement officers were scared of him, the defense attorneys were scared of him. He was on the Guinness Book of World Records for most death sentences. And when he picked a target and decided someone was guilty of a crime, he was going to get a death sentence. And here, the Red Springs Police Department, someone on that department had a doubt about Henry and Leon. So a few days before Henry and Leon's trial, they asked the state crime lab to test fingerprints on beer cans found at the scene with Roscoe Artis's fingerprints. So somebody in law enforcement was saying, you know, Joe Freeman's going for this, but I'm not so sure. So SBI, please test it. Now, then the trial happened, the convictions happened, the death sentences happened, and everything was put on hold. SBI, a year later, in its record said, we did not do the testing. We discontinued, there was a conviction, we did not do the testing of Roscoe Artis's fingerprints. So what's happened? You had tunnel vision of law enforcement. We've got our guy, no further investigations needed. You had a prosecutor who got a conviction and who wasn't about to acknowledge any mistakes. And that's including after the governor granted the pardon of innocence. Joe Freeman Britt from retirement comes out and says it was a mistake, he shouldn't have done it. So it's a problem. And I would invite prosecutors and former prosecutors and former law enforcement to start talking about this. And we would love to have those kind of conversations, because those are what are going to change things. Right. We would love to see that. So that's the answer I can give you.
And law enforcement has said absolutely nothing about the Henry McCollum case, right? I mean, they have not made any statements on what happened.
My question to you all has to do with what seems to be the changing public attitudes towards the death penalty, that we really do seem to be making some headway, that public opinion seems to be shifting. Every couple of weeks I go on this conservative talk show with a local screamer on the radio, a guy named Bill LeMay on WPTF. And LeMay and I, he's way out on the right, and we disagree on just about everything, but he actually has now told me, I've concluded the death penalty is hopeless. It's impossible to impose in a fair way. I don't trust the government to do anything, which is sort of an interesting conservative perspective. But even he now has embraced the position that it's hopeless. It can't be meted out in a fair way. Are you all sensing that? Do you get feedback in your position of working on this issue every day that sea change is really happening?
Absolutely. I mean, first of all, we just don't see any evidence that the public is clamoring for executions in North Carolina. We haven't had one since 2006, and there just doesn't seem to be any evidence of the public wishing that we were having them or the crime rate going up. We're seeing very, very few death sentences being handed down. We're seeing polls. When you ask people, do you support the death penalty, you'll get a majority that say yes. But when you ask people, would you support replacing the death penalty with life without parole, you'll often get a majority saying yes to that and favoring replacing the death penalty. So we're also seeing the growth of a chapter of conservatives concerned about the death penalty in North Carolina. So that's been a big development here.
Other questions that folks may have? Dick.
You mentioned the attempts to deal with the larger criminal justice system, to get them to recognize this problem. And I just hope that you or some of the lawyers you mentioned could approach the DAs and the courts, because they must have things like ethics and codes of conduct, and to be able to say, in this case, they're not following their mandate, they're not delivering justice, because what this means, I think what you're saying is 56 murderers walk free, and that there must be some standards they could apply. There are standards for labs and everything about when is it appropriate to bring this death penalty case based on the strength of the evidence or something like that. Not just the horrific nature of the crime, but also sort of a code of conduct as to when to go, because that's what this all means. That they're endorsing a system which sort of routinely lets murderers go free.
No, you're absolutely right. And I think the one thing I would say back to you is, in terms of us and our ilk, having a conversation with the district attorneys. That's much harder. I mean, we're in a very adversarial legal system, and I think what needs to happen in a lot of, particularly these smaller counties, district attorneys are elected officials, and they are responsible, they should be responsible to the citizenry. And their job is not to seek convictions, it's public safety more broadly defined. And we as citizens need to be pressing them on what are you doing that is making my community safe, that is not being, where we're not over-policing people of color, where we're not incarcerating people at such large numbers at such great cost to our society in many ways. There's lots of things we rightfully should be asking prosecutors for, not just in the death penalty realm, and that really has to come from citizens. But one of the nice things about the report, when you look at it online, you'll see in the back all the cases that all 56 cases are listed out, they're listed by county, and if there are county cases from where you're from, where you have connections, where you have relatives, y'all need to be talking to those folks about what's going on there.
The report is at cdpl.org. CD, Center for Death Penalty Litigation.org. CDPL. Let's go to the very back. That's you.
Scott.
Scott.
Yeah, and you touched on this, but I don't think you quite answered my question. I wonder what, have been wondering ever since I heard about the report, have you gotten any response from the DA's Association or the Bar Association or anybody in your profession who doesn't do capital defense?
I don't think so. No, the only thing I heard, WUNC reported that the District Attorneys Association wanted to review the cases before they made any kind of comment.
And that'll take 30 years.
Yeah, we've heard no feedback from.
Maybe we'll have to keep pressing them. Yes, sir, right here in the middle.
You remember in the aftermath when Gail, and was it Hunt? Was the other guy?
Daryl.
There was, from the reports, there's clearly malfeasance on the part of the prosecutor, the man and the woman. The guy went on to be a highly placed person in the judicial system, and I don't remember the name of the judge, and that's probably a good thing, had a hissy fit because this man had been impugned. How can anybody have any sort of sense of optimism in this kind of environment?
Who wants to answer that one? Well, I think that from my perspective, that what Kristen was alluding to, the changing public opinion, I think it's increasingly clear that average members of the public, partially maybe even as a result of dramas on television that now so effectively show the wrongful prosecutions of the people that are proved to be innocent, who seem so clearly to be guilty. I think it's changing. I just feel I feel a sea change underway, and that's where I derive my hope from, not necessarily from the officials who have been backed into corners so much. I don't know if you all have anything to add to that.
Yeah, I do. So here's some signs of change. We used to sentence on average 25 to 30 people to death a year in North Carolina during the 1990s. We were sentencing 2 people to death a year. Juries, or death qualified juries, are sentencing 2 people a year, a death a year. And a couple years ago it was 0. So that is a huge change. Prosecutors now have discretion to decide whether or not to seek death, and they are not seeking death nearly as much as they used to in the 1990s. So there have been some positive changes. And 7 states in 8 years approximately have repealed the death penalty. So
most recently, the very conservative state of Nebraska, which passed it as a bill in the General Assembly and overrode a gubernatorial veto. You have a question right here?
On that point, absent a repeal, what kind of policy initiatives, has there been anything proposed to limit it? You touched upon it a little bit, Gretchen, about.
Well, the current legislature, there's not a lot of interest in listening. Although, I mean, it's kind of
opposite.
We do have this, dialogue with these Armenians conservatives concerned about the death penalty, and there are folks who are interested in abolition. At one time, we had some hope that the there might be a mental illness exemption on the death penalty comparable to what we have for intellectual disability. That, you know, I mean, with the current legislature, I think often what our feeling is, even if you think you might want to tinker around the edges with something positive, I'd rather it not get out to the floor where it would be open to all kinds of mayhem in this house. So.
Fair enough. How about anybody else who has that? Ma'am, you haven't asked a question.
I just had a question about the protocol and the drugs, and I think that's where the moratorium is now in North Carolina. And that's going to, how long, where in the court system is it? How long would it be? I mean, won't that be the next kind of big thing to you know, when that ruling comes down, that would give a big impetus to again, you know, in other words, that we could all coalesce around?
So there's actually two things that are going on. And one of them, as you rightly identified, is the lethal injection lawsuit, which has been back and forth between Judge Stevens over here in Wake County and to the various appellate courts. And the most recent action that happened at the end of last year was that lawsuit then got transferred to federal court. And it may be coming back to state court, but at some point there's an attorney who used to do death penalty defense work and now works at the School of Government advising prosecutors, and he described this all as a Gordian knot, which you know, we're not unhappy about, right? And until it's unraveled, nothing can really go forward. The other thing that's happening is, despite the repeal of the Racial Justice Act, about 145 or so of the folks on death row have pending Racial Justice Act motions, and those motions are going to remain pending until the North Carolina Supreme Court takes on the question of, does the repeal apply backwards to take away from people if they properly follow the law as it was enacted at the time in 2010? Are they now out of luck? And that case has not even been accepted for review yet.
By the Court of Appeals or by the
Supreme Court of North Carolina. And so, I mean, that's going to take a little bit of time as well. And
couple of years, I mean, at least?
I think we're going to make our decade of execution free. If I had to bet, I would say we were going to make a decade.
Right.
We're close to 9, right? So, yeah.
So when we get it repealed, will you change the name of your organization when we get it repealed?
Center Against Life.
Other questions that folks may have? Last call. One more in the back from Leo.
One more question. While you're talking about cases correction, can you talk about the case the United States Supreme Court just took on race out of Georgia?
Oh yeah, no, that's a great case. So this was a case that involved jury selection and the question of the prosecution's exclusion of African Americans from the jury. It's a black on white crime, and the conviction was returned and the death sentence imposed by an all-white jury after the prosecution struck 4 out of 4 African Americans. The defense at trial said, we think there's a problem. We think you violated the U.S. Supreme Court case called Batson. You're not supposed to be getting rid of all the African Americans. We think it might be motivated by race, and we want you to explain why you're getting rid of these people. And the prosecutor stood up and gave a real litany of reasons for each of the people. And the judge, as most judges all over the country, and especially in North Carolina, say, well, okay, that sounds good to me. That sounds race neutral. I'm sure race had nothing to do with it. See you at the country club after court, right? And the appellate courts did not disturb that finding. 19 years later, public records request, the defense gets notes from the district attorney's office. Lots of internal memoranda showing, you know, before a trial, the lawyers know who's going to be called for jury duty. And so they can go and take that list to their friends, and they'll say, ooh, cashier, and she's liberal, get rid of her. Or let's keep her if we can. And so these lists were all marked up and they're highlighted. And it becomes very clear that there's this color coding that's going on related to African Americans. And there's comments about the B1, B2, B3, and B4 that are going to be struck. There's some reference to if we have to take a black, this is the one to take. And these, of course, were contrary to the reasons that were advanced at trial. I mean, it's a great case. It's obviously, I mean, in some ways, from a lawyer's perspective, it's like, oh yeah, they take the case that has amazing proof, and your sort of garden variety jury selection discrimination claim, how is that going to be helped by this extraordinary case? But I think the resonance for us at our office, having litigated the Golphin and Walters and Augustine cases, where we had very comparable notes, the same kind of thing, where the prosecutor went, talked to law enforcement in the county where the trial was changed to a different venue, and they had notes about the respectable black juror and the black wino and the white country boy who was okay, even though he drinks a lot compared to the black wino. So these things showing that, you know, that we're not alone in this, that this really happens, and we hope that the Supreme Court will really smack this case down, because it's pretty ugly.
Well, they seem to be doing better up there at the Supreme Court.
The big liberal drift.
Well, okay, one final question. I see one last arm.
So what would you recommend for those of us that aren't lawyers, Regin, Kristen?
Oh, yeah.
Where's our last slide?
Oh, sorry.
Thank you, Melanie. She's not a plant.
Oh, man, this is going to force me to do this.
Oh, well, but in case, we have a, CDPL is where you can find the report, but if you want to sort of learn what's happening with the death penalty, start signing up for updates about what you can do and learn the news about it, it's ncdeathpenalty.org is a website that we help maintain of the Coalition for Alternatives to the Death Penalty. And you can also be a part of our Facebook network, North Carolina Coalition for Alternatives to the Death Penalty, and on Twitter it's at NCCADP. But you can find all the information about that at ncdeathpenalty.org. So go there, sign up for our email list, and then get in touch with us, and you can get more involved.
And to add on to that, second part of my question is, given the political makeup of our legislature, do we wait until 2016 if there are, people like students that want to take action in some way in some kind of grassroots movement, or what would you recommend as an outlet?
So there's a legislature, but there's also the governor and the people running for governor. The governor can halt executions and commute all the death sentences. So I recommend people talk to those candidates and talk to the attorney general candidates and say to them, this isn't working. We need to stop this. And please, if you become governor, or if you are the governor, commute death sentences.
Been done in other states.
It's happened in Illinois, I think.
Yes.
That's right. Well, thank you all very much for attending. Please join me in thanking our speakers.